Hello and welcome to my new channel. I'm going to use this channel to comment on court cases, car chases, First Amendment frauditors, and sovereign citizen fails. So for my first video, we're going to keep things really light. We're going to go watch a hearing held a couple of days ago. I think it was a Monday, March 21st of this year, and it was about 4 o'clock. Takes place in Judge Martin Hoffman's courtroom, which is the 68th District of Texas. It's all about a car chase, but that's really pretty much irrelevant to the content. I want you to pay attention to the attorney there at the top and in the center. I'm going to try and put a arrow on top of him, but I want you to pay attention specifically to him. Thanks. Oh, and I'll voice over as things happen.
All right, let's go ahead and proceed.
Well, Your Honor, this is defendant's motion to compel. I sent an interrogatory and a request for production to the plaintiff requesting or asking whether in this personal injury case, the plaintiff's medical expenses were covered by a letter of protection. And then I requested
Okay, so it's right about here. You'll notice he puts his head on his hand. You know, and it's like 4 o'clock, so keep watching his eyes.
And the plaintiff objected on the basis that this was an LOP.
Oh man, here goes the head drop, and the eyes are fluttering. He's really getting sleepy. He's hit that 3 or 4 p.m. post-lunch wall, and he's barely paying attention.
Let me just ask this, because I've dealt with this issue many times. I know that there's a couple new cases out of the Texas Supreme Court.
All right, now his eyes are back fluttering again. He's barely paying attention. Head on his hand. He's really getting sleepy. And that attorney, he's just monotone. He's just going on about his case.
I don't remember
this poor guy, Mr. Clay, he's having a hard time.
I believe in that case, the court upheld the production of the LOP, but to be fair, I don't remember language saying, LOPs are always discoverable or anything that definitive. But what it did say is that in an LOP situation, the physician...
All right, he's been looking at his computer now. He's trying to keep himself awake. You can tell.
And in my mind, that alone makes the LOP discoverable, because that's certainly not the usual situation between a doctor and a patient. And it's evidence of bias, first of all, and particularly in a letter of protection case where the typical LOP is on referral from an attorney.
I'll tell you right here, I'm listening to that attorney, and I'm getting bored myself.
16th year, I've never let in LOPs unless the plaintiffs agreed to do it, which a couple times they've opened the door on it. But and I've never let in attorney referrals again, unless the plaintiff's attorney opens the door or their clients. Sometimes their clients just start testifying about it, and so unless there's
all right, I actually really like watching Judge.
Any of these cases, and I've read.
What's his name? I can't think of it. I can't even see it on my screen. I actually like watching his court. He's kind of funny, but he is a little bit monotone. Although I guess in some cases I'm a little monotone.
I saw that an LOP had to be produced in discovery, and so until the Supreme Court or the Dallas Court of Appeals tells me otherwise, I don't anticipating changing my long-standing practice. I don't think it's relevant, and I don't think it's. I think it just could lead us down a long rabbit trail that is unnecessary. So, but Mr. Clay, do you want to just volunteer?
All right, right here you'll see he's still pretty sleepy, but
No,
he's
Your Honor. I
gonna
mean, I agree with
respond
the court. I think that
to
these aren't relevant to any
the
issue in the
defense
case. Have made objections on
attorney
it
and
based off
the
it's a
judge.
collateral
And
source
he's been
and the
half
fact that
asleep, but
there's something of
I
value
think
in
he's
exchange with the
probably done
provider
this
in
enough that
exchange for,
he's formulated a
if it's
coherent
a third
response.
party
And
medical providers
but
agreed to
he
forego
still
payment on a
even looks
deferred payment
sleepy at this
agreement.
point.
And so that's why it's the basis of the objection is that it's collateral source. It's further, it's attorney work product. It's prepared by an attorney in the course of litigation. I wouldn't volunteer to voluntarily turn it over. I don't think it's relevant or admissible at trial. And so I don't think it's likely to lead to the discovery of admissible evidence.
Well, Your
So what I
Honor,
would suggest we do is I'll just deny the motion to compel. I know that the law is constantly changing in this area, Mr. Wendt. And so if you want to re-raise this, if there's a new case out of the Supreme Court that changes the law or the Dallas Court of Appeals, I'm happy to look at that. If there's a case out of another jurisdiction, my feeling is I don't want to waste your time because I'm not going to change my view on this.
All right, here we go
required to
again.
by
Put his head back on his hand,
mandatory authority.
and the
So-
eyes are
so I don't
starting to
wanna
get a
waste
little
anybody's
droopy,
time on this.
and I think he's starting to get sleepy again. And the judge and the
sounds
defense
like you don't want to
attorney,
hear my argument
they're
about
just going
plaintiff's
back and forth.
objections.
They're not really, it's not an
what-
exciting
I don't
topic.
want to. I don't want to
They're
waste
really
your time.
just
I've been doing this a
monotone
long
and
time,
boring.
so
It's late in the
I don't think that I should
afternoon.
treat your.
My man needs a
I try to
Snickers,
be as consistent
but
as possible.
he's just
especially in
barely,
these car wreck
he's
cases, in every
half-heartedly
case,
paying
but especially in
attention.
car wreck
But I
cases,
will
you
give
see the
him
same
full
issue
credit
over and over
in
and over
every
again.
point.
So if I
Whatever
started treating
either
your
one of the
firm
judge or the
differently than I
defense
do
attorney
other
says,
firms, the same
he has a
situation, people would
coherent,
ask, well,
logically thought
why
out,
is your firm being
well-based
treated differently? Why do they get
response.
the
But man,
special
he is
treatment?
getting
And
sleepy.
this is how I do it in every single case. And until I'm told otherwise by the Supreme Court or by the Dallas Court of Appeals. But if you want to make your argument and whatever you want to say, I'm not trying to stop you. I just don't want to waste your time.
Well, I will be very
Now
brief
we're
in trying
back
to
to the
persuade
head on the
court
hand
that
and the droopy
time has
eyes.
come. First
I
of
think
all,
the judge has
this
noticed
isn't,
at this point.
a collateral source.
There is a little bit of a mimicry that goes on with body language, and the judge is actually doing a little bit of it. As you'll notice, people do tend to mimic each other a little bit during court
I'm
hearings.
very aware of what letters
You see they move their hands at the same time. That's all body language stuff that you start analyzing once you get into trial practice and stuff.
Letters of protection.
That's really not what my point on these discussions is, because I don't want to be accused of practicing without a license. My whole point is to make, look at this dude. I feel bad for him, man. It's late in the afternoon. He just wants to have a nap. He'd probably be solid if he had an hour nap and then came back to work. But man, he is tired. You can see it.
And then the court ought to allow them to be discoverable and then rule as to whether or not they
All right, right here you'll notice I can't even tell. I think there was some of those micro sleeps that he might have actually been completely asleep, just sitting with his head up. It's those little micro sleeps that you can get. I get them sometimes when I drive late at night and get that white line fever. But yeah, this is not an exciting hearing. I didn't want to do an exciting hearing for my first video because I'm really just learning this whole technology, hugabaloo. But I just feel bad for the guy. Look at him. He is just so tired. He just wants to end this call and get this over with. You can just see it on his face. Look at him. And his client is right underneath of him in the picture. And the client is sitting there like, I have no idea what is going on, but I'm going to look like I'm paying attention.
Knowing that, the plaintiff is still allowed to submit the charge master retail rates charged by the LOP physicians. But we all know,
kind of another reason I wanted to do this kind of video is, this is what you see as the nitty gritty, day in, day out This is what
If
attorneys
there are
actually
numerous
do.
contingencies in the
And when you see
LOP,
these sovereign
it may
citizens
be
and they're in there citing
possible to
cases that are
understand or to
just, they're
ascertain
misciting them, they're not
what
applying
the
the law
actual
correctly,
amount
they don't
incurred
have any
is or
understanding
will
what a
be.
lawyer does. They
And
think they're
that's why I
being all
think they're at
lawyer
least
like.
admissible, or
And when
excuse
you
me,
watch a sovereign
discoverable.
citizen video
And
versus
it,
what
they
an
may
attorney
or may
video
not
looks
be
like,
admissible in
and you
trial.
see how
But
attorneys actually do
part of the
this
reason I
and how they
submitted the
actually apply the law
to
to case
determine
law,
whether it
and
is
they argue their cases
ascertainable
properly,
or
and
whether the
they're
amount paid or
deferential
incurred
to
for
the
any particular
judge.
provider
And you see these
is
sovereign citizens on the
ascertainable
street,
before
and they're
trial,
not
or whether
deferential
that's
to
just
the
something to
authority
be worked
figure,
out
which
later
would be the
between the
police.
attorney
They don't
and
make coherent
the
arguments.
doctor.
They don't apply the law
So
correctly.
that's
They
why I think it's
misstate case
relevant. And
law.
that's the
They
problem with
think they
LOPs
are
because
somehow
uh,
a legal
right
expert
now,
because
if they're not
they read
admissible,
one
the plaintiff
case
is
and they
allowed to
watch a lot of
submit
internet
the
videos,
bills from the
and
LOP
it's
doctor,
nothing like what it is
uh,
in the real world
perhaps
to
with
work this day in and
explicit
day out.
contingencies
So
that tend to
I hope the
reduce the
video
amount
here
that's actually
gives you a
incurred.
little
And that
perspective
is what I
of what
believe the
a normal
defendants have a
day
right to
is
at
like.
least discover.
And now this isn't the kind of thing that I ever did. This is all civil
Clay, do you
car
agree?
accident
I disagree,
stuff,
Your
but
Honor.
the concept is
I don't think
similar.
that these are discoverable. The LLP themselves aren't going to be admissible at trial, as the court's indicated. This case doesn't differ substantially from many other cases. Um, it's, the other cases involving letters of protection.
All right, you just
The
heard him talk
agreement is that
about
the providers are going to
how
say if on a trial they
he's
expect to
cited
get
some
paid in full and they
cases,
base their bill.
he
On some cases, they
applied
do
the
have to reduce on a
law,
case by
and
case
he's telling the
basis, but it's
judge
not going
now how
to
the law
control.
applies
The LLPs themselves aren't
to
going to be
this
admissible. It's not
particular
seeking
case
discovery of admissible
and the
evidence
other
where
cases
information
that
is
have
likely
been
to lead to
cited
the
by the
discovery of
defense
admissible
counsel.
evidence.
And
In
you see, he's made a
in the
good,
defendant's
coherent
brief, they
argument,
cited to K&L
even
Auto
though he's
Crushers,
been
claiming that it
half
allows discovery of
asleep.
LLPs. That's not
This
what the
is
case
what it's
said.
like
That
for
wasn't
when
a disputed issue
you're
between the parties in
actually
that
an
case. It was
attorney.
seeking third-party discovery on reimbursement rates from the actual provider himself. They cited to page 250 of the opinion. I pulled up page 250 of the opinion. There's nothing on that page in the opinion that compels discovery of the actual letters of protection. So on that basis, I would disagree, Your Honor. I don't think this case is substantially different. It hasn't changed the law on this subject. It's seeking evidence that's not going to be admissible at trial. So on that basis, we would continue to maintain our objections.
Well, Your Honor, it could certainly lead to the admissibility of admissible evidence, because if there are, at a minimum, if there are contingencies in the LOPs, then it will tell us
Also,
whether or
just so you don't
not
think I'm ragging on other
it is
attorneys,
likely that the billed
Mr.
amount
Wendt
will
is
be
doing a
reduced,
fantastic
or
job.
whether somebody is going to have to make a
I hate to keep
determination
harping on it,
about
but here
what's a
we go again.
reasonable amount
He's
under
back.
the
He's relaxed.
circumstances
He's put his
of the
hand on his
case,
head. He's going to start
or
to nod off.
what's
And I
medically
don't know, in case
necessary,
you're
or
interested,
what a reasonable
people who
charge
might be
is.
watching
And those
court for
are
the first time.
all the kinds of
But
things that
the
are
gentleman
contained in
underneath the
letters of
attorney,
protection in order
which
to
would be the bottom
protect
row center,
the plaintiff
that's the
from
client.
just having
His
to
attorney is directly above him.
pay
That would
what
be
we
Mr.
all know is an
Clay.
inflated
The lady
rate.
on the phone there, she's the
And that's why I
clerk
believe they're
in the
at a
clerk's
minimum
office
discoverable. And
that handles all the paperwork
again,
for the judge.
reiterating, if
And then the young lady
if
at
a
the
treating
bottom,
doctor
all the way
has a
over
direct financial
where you
stake
can't
in
see her hands,
the
that's
outcome
the
of the
court
case,
reporter. And of course, she's
I think that alone is
taking down
enough.
everything
So,
that's said in the hearing. And as you see, here
Anything
he goes.
else?
He is just
Don't
about
go, Your Honor.
asleep. Judge has not
All right,
noticed
I'm
him.
gonna
Judge is
do what
being kind of
calculated
polite,
when I
not saying
started.
anything.
So
I'm sure he
I'm gonna
has.
sustain the
He's probably
objection
got a good
to
laugh out of this.
production of this and deny the motion to compel. Do you have an order for me, Mr. Clay?
I
All right,
don't, but
this
I'll
is going
give
to
it
be
to you,
my
Your Honor,
last
today.
voiceover. You'll
Make
notice
sure at the
Mr. Wendt
beginning of the
lost
order it says
on
that
his
this was
motion,
heard on
but
March
he's polite.
18th,
He said thank
2022, as
you,
opposed to on this
and
day.
he's just ready
Make
to
sure
move
you
on.
share it
He
with Mr.
lost.
Wendt.
He's not
Make sure
argumentative,
that we
and he's really
can
polite to the judge.
email
Thank
it to
you,
Rhonda
and
as well
that's
as
it. I
speaking
mean,
5 at this
that's
time.
all you have to
Yes,
do
sir.
is just be
Okay.
nice.
Thank you, guys. Good to see you. And if the law changes on this, let me know.
All right. Thank you, Your Honor.
thank
you,
you for
guys.
listening, Your Honor.
No problem. You have a good day.
Well, that's it. It's over. I hope you enjoyed the video. I know it's probably not my best work, but if you did like it, like and subscribe. I'm going to try and do videos on a pretty regular basis from now on. Thanks. Bye bye.